In what promises to be one of the most consequential hearings this term, the Supreme Court is currently mulling two cases with major repercussions for social media platforms. The cases involve a pair of laws from Florida and Texas that bar social media platforms from banning users based on their political views, even if users supposedly violate platform policies. The outcome could have big implications for free speech online and curb companies' ability to enforce their own rules. Platforms like Facebook and YouTube say both laws infringe upon the company's free speech rights by restricting their ability to choose what content they wish to publish on their platforms.
However, conservatives argue that these bills are necessary to protect the free speech rights of right-leaning individuals online. These laws were, in fact, born in 2021 after Twitter, Facebook, and others banned former President Donald Trump following backlash from some conservatives who maintained that the social media companies were unfairly instituting policies that specifically targeted conservative figures while not practicing similar persecution of other ideological users. Now, the case marks the first time the court will really weigh in on the First Amendment rights of social media platforms. Now, of note, former President Donald Trump has expressed his support of the lawsuit, while the Biden administration filed an amicus brief on behalf of the social media platforms.
Following arguments, the justices appeared skeptical about the constitutionality of the laws and how they might impact other sites like Uber without violating the First Amendment. Justice Elena Kagan pressed Florida Solicitor General Henry Whitaker over the First Amendment merits of the case, asking how the law wasn't, quote, a classic First Amendment violation. Justice Clarence Thomas concurred, asking for, quote, one example of a case in which we said that the First Amendment protects the right to censor. Justices Amy Coney Barrett and Brett Kavanaugh seem to side more with Florida. According to some reports, some of the 9 justices are considering sending the cases back down to lower courts.
Yes, so this is a very important set of cases involving these state laws that restrict the ability of social media companies to remove users for political speech, specifically tied to what happened to Donald Trump. Now, look, the issue is I think censorship is bad. I think a lot of the things social media companies have done, a lot of their policies have been not good. They have wrongly removed users. They have suppressed content related to COVID and other subjects. Now, we've subsequently learned a lot of that was actually not freely chosen by the companies, but was in fact forced on them by the government. That's a whole different Supreme Court case that's going to be happening in the coming weeks that I'm looking forward to. But in this case, fundamentally, look, if you believe in the First Amendment and you believe in free speech, I mean, it is the case that Facebook, however big and powerful it might be, is not the government. It is a private actor, and it can set policies on what rules you're supposed to follow, and it can remove users. And this was an example of the states trying to take that power away from the platforms in ways that I think obviously do themselves violate the First Amendment, which was kind of what was coming up in the oral arguments. Now, it gets more complicated than that because there's these specific laws that apply to social media companies, Section 230, which shields them from some liability. And I know many conservatives are arguing because they have this special protection from being sued that other publishers don't have, it should be different. But then the other people will say, okay, but that's just not the way the law is written. If you want to change this, you could change the law. The law doesn't have to. It's not actually the First Amendment, it's Section 230, but no one has changed it. So the law does give them this protection while still allowing them to make editorial decisions. So the arguments were very interesting, and I'm not totally sure which way the case is going to go. I suspect they will strike down the laws because at the heart of it, the government can't tell a private actor what speech policies it should have is pretty ironclad.
Yeah, it does feel as though the problem here is the problem that these social media companies keep butting up against, which is that they're somewhere between a publisher and a common carrier. If you think about them as common carriers and you ask yourself the question, should AT&T be allowed to restrict access to your weird uncle because his political views are unsavory? Obviously, that feels wrong. But the difference between your weird uncle making a private phone call to someone else and broadcasting content on a platform that has this relationship very publicly with that content does feel a little bit different. And that's not me making a judgment on where I think this should go, but just an observation that that liminal space between being a publisher, a la the New York Times, let's say, who we completely appreciate has the right to run what it wants to run and make editorial decisions, and the kind of more private end-to-end facilitation that these kind of common carriers, whether it's a telephone company or a railroad, servicing individuals in their personal lives as opposed to this broadcast function, it seems to be really at the heart of why these decisions are difficult and why you find people who are once on one side of this argument, let's say in the famous gay cake case where two religious bakers did not want to make a wedding cake for a gay couple and were not forced to do so by the courts. The conservatives are now on the opposite side of this, saying the proverbial cake maker in this instance is the Facebook, who should be forced to host whatever views are put on the site. In this case, maybe Donald Trump or whomever.
Right. That's why, my position is the cake baker absolutely should not have to make that cake, but for exactly similar reasons, I don't think at the end of the day Facebook should be forced to carry any one entity's content. And the comparison to the phone company or the railroad, I think it's easier to see why these things are, why Facebook versus AT&T is distinct when you actually consider the revenue models. Like the phone company, you're a subscriber, you just pay for the service. The railroad company, you buy a ticket. You don't pay to use Facebook. Facebook's business model is creating a curated advertising experience exercising some control over what is on the platform so that it makes money, because it makes money through ads. Yeah. So then to say, it's a free service to you. You would maybe have some rights if you were handing them over money and then signing some agreement, that would make more logical sense. But it's a free service because what it sells is the easier experience. So to say that this, just like the New York Times, can't craft what its product is in order to make it more appealing from advertisers to revenue. If the government tried to say, we want this much of this perspective on the front pages of the New York Times, we would all recognize how obviously a violation of the First Amendment that is. The Facebook case is, this is what's being decided and litigated, but I would say the Facebook case is more akin to that.
I think that's right. I also think that the implications of this could be potentially very dire. It wasn't nothing that Trump got banned. And for me, the problem here is at least one of these state rules, I forget which, would preclude you from banning someone even for violations of the policies. Now, my feeling, and we've had this conversation with respect to Twitter and how Elon Musk was planning to and did or did not actually change Twitter, the issue was a perceived inconsistency in how the Twitter rules were applied. I don't like that. I think that there is some value in not allowing the CEOs of various websites to exert their own political will, but to apply in a fair-handed way policies that seem well-tailored to keeping the site a place where advertisers want to be. No pornography, no incitement of violence, those kinds of things. But I do have concerns about this could go against the left, this could go against the right, this could go against the people in favor of the elites. What happens if these social media sites that have been so instrumental to movement efforts in recent history, with all the hashtag movements and the like, do have carte blanche to shut down broad swaths of political discourse at the drop of a hat, and there's absolutely no pushback? In a world where we know there's not the same ability to simply go to a different bakery. These websites are powerful and they have value in part because they are centralized. There is only one, and all your friends are going to be there. They behave as public forums in a way that is very different than any given bakery or individual provider. And so I do wonder if there's some kind of balance or middle ground or protections that could be put into place that falls short of what these laws are recommending. But I don't think this broader issue of who is going to protect the rights of individuals in speech spaces, which are technically private and where they don't really have any rights, what's going to happen?
And again, you could do that. Like Section 230, which is the law that protects them from this liability, could be restructured to say, well, they get it if they also are transparent about algorithm. It could be not given so carte blanche. That would require, but the Supreme Court just has to interpret it the way it is. And the way is currently written is very clear that it extends this protection no matter what other moderation decisions they make.
Yeah.
So, that's going to be a failing of Congress. I'm also worried in these laws how it describes what constitutes a political belief.
Yeah.
What even counts as a social media platform is not as clear. I can't remember if it's Texas or Florida. One of them is more clear on we're talking about Facebook and Twitter, not just a website, but the other one's not as clear on that. And then is ISIS a political view? We were just at a hearing a couple of weeks ago where everyone was screaming at Mark Zuckerberg for not taking down more abusive content, not protecting kids from bad actors and con men and people who are trying to encourage you to commit suicide. Do we really want 5 conversations ago, it was the platforms aren't exercising enough control to take down bad actors and people who think they're violating their policies, and now you're saying they're doing it too much, which is the position that I do find myself sometimes sympathetic, frankly, to the people trying to run these companies because they're just being screamed at by political actors for totally contradictory reasons.
Yeah, and look, 2 months ago, Congress passed a resolution saying that it was de facto anti-Semitism to say free Palestine, to say from the river to the sea. What does that mean for the left looking down the barrel of these laws? I understand that these are brought by conservative governments in the interest of kind of protecting Trump-adjacent politics. But we have seen the liberals who run places like Atlanta criminalize the protest movements around Cop City. We have seen a bipartisan Congress censor Rashida Tlaib for saying from the river to the sea, and calling that a hateful language, almost by law.
Yeah.
So, do we really want to go down that path? I don't know. The problem is that people are defining what is and isn't hate speech and what is and is not allowable, regardless, in both directions, all over the place, on the federal government level, and now this attempt on the state government level.
You're very right to bring that up, because while these specific bills were brought by were constructed by conservatives, there is support from some, not even just liberals, some on the left. I think Bernie Sanders and Elizabeth Warren and Amy Klobuchar have all also said they want to get rid of Section 230 for similar-ish kind of, because of hate speech and because of the danger, and so he doesn't want to reward those platforms for having platformed any of these people in the past. And the idea would be to construct some kind of panel that determines whether your website is non-hateful enough to get these kinds of protections. That just seems like a really bad idea to go down that route. Yeah. All right, tell us what you think about these hearings and internet law, and we'll be back with more Rising right after this.